Welcome to the Deep Dive. Today we're getting into something pretty important for a lot of Californians, the eviction court hearing process.
It really is.
And this is right up your alley, working with Martinez Law Center in Santa Ana. You guys focus specifically on tenant rights, right? Unlawful detainers mainly.
That's correct. We focus on representing tenants, never landlords, in unlawful detainer cases across Orange County, Riverside, San Diego, and Los Angeles.
Good to know. And Martinez Law Center handles other things too.
Yes. Besides tenant defense in evictions, we also handle real estate partitions, auto accidents, premises liability for apartment issues, and workers' comp. But the focus for eviction is strictly tenants.
Got it. And folks can find you at martinezlawcenter.com.
That's the place, martinezlawcenter.com.
Okay. So our mission today, our deep dive, is really to break down what happens during these eviction hearings in California.
Exactly, from start to finish. What leads up to it, what happens in court, possible defenses for tenants, and, what happens after the judge decides. It's crucial info.
And we've pulled this together from reliable sources like the California Eviction Court Guide, FAQs, process documents, trying to make it clear.
Yep, aiming for clarity.
So let's jump in. Where does this whole journey to eviction court actually begin?
Well, it all starts with a piece of paper, a written notice from the landlord.
Not just any note, though, right?
Definitely not. It could be, say, a 3-day notice to pay rent or fix something, but it has to follow California law. We're talking Code of Civil Procedure, Section 1161.
Specific requirements.
Very specific, what it says, how it's delivered. If that initial notice isn't legally spot on, that can be a major issue for the landlord's case later. It's like the foundation,
Makes sense. A shaky foundation.
Exactly. The whole thing could potentially crumble.
Okay, so the tenant gets this formal notice. What if they don't, or maybe can't, do what it says in time?
Right. If they don't pay the rent demanded or fix the lease issue within that time frame, like the 3 days, then the landlord can choose to escalate. They can go to court and file an unlawful detainer complaint.
That's the actual lawsuit.
That's the lawsuit, yeah. It's specifically designed to get possession of the property back.
And then the tenant finds out how.
The landlord has to formally serve the tenant. That means delivering a summons, that's court form SUM 130, and a copy of that complaint they filed.
And serving has rules, too.
Oh, absolutely. Strict rules about how it has to be done to be legally valid.
Now, I heard there's been a change recently in how long tenants have to respond once they get those papers.
Yes, that's a really, really important update. Huge for tenants.
What changed?
Okay, so it used to be just 5 days, which is incredibly fast. But thanks to recent legislation, AB 2347, tenants now have 10 business days.
10 business days. So weekends don't count.
Right. 10 business days from when they were properly served to file their response with the court.
And that response is usually?
Typically, it's an answer. That's Form UD 105, but they could file other legal motions, too.
That extra time must make a big difference.
It's potentially a game changer. It gives tenants more breathing room to, get legal advice, maybe from us at Martinez Law Center if they're in our service area, or another legal aid group, and actually prepare their defense properly.
Definitely sounds crucial when you're facing losing your home. Okay, so the tenant gets their answer filed within those 10 business days. What happens next?
If they file that response, the court generally sets a hearing pretty quickly. The law, CCP 11178.5a, actually says if someone requests a trial, it has to be set within 20 days.
Wow, still pretty fast.
It is. Unlawful detainers move fast. But here's the critical part. What if the tenant doesn't file a response?
Within the 10 business days.
Right. If no response is filed, the landlord can just ask the court for a default judgment. Meaning the landlord could win automatically without any hearing. The tenant could be ordered out just because they didn't respond to the lawsuit.
So lesson number 1, don't ignore those papers. Respond.
Absolutely. It's probably the single most important thing a tenant can do at that stage.
Okay, let's imagine the tenant did respond and a hearing date is set. What's it actually like at the courthouse on that day?
Well, expect it to be busy and potentially a bit chaotic. Eviction courts often handle a lot of cases on the same day.
So not just your case.
Oh, no. Usually many cases are scheduled back to back. You might be told to arrive at, say, 8:30 a.m., but your case might not be called until much later. Be prepared to spend, realistically, maybe 4 hours there.
4 hours. Okay, good to know. Pack snacks, maybe.
Maybe. But seriously, plan for a wait.
And what should a tenant absolutely bring with them to the hearing?
Okay, preparation is key. First, bring the copy of the answer form you filed. That's your official response.
Got it. What else?
All your evidence, anything that supports your side of the story.
Like what specifically?
Like rent receipts or bank statements if the issue is non-payment, photos or videos if you're claiming the place is uninhabitable, mold, pests, broken heater.
Pictures of the problems.
Exactly. Copies of letters, emails, texts you sent the landlord about repairs. Even bring the original eviction notice itself if you think there's something wrong with it or how they gave it to you.
Anything else? Witnesses.
Yes, if you have witnesses who saw something important or can back up your claims, make sure they can come to court.
And you mentioned something about writing things down.
Oh, yeah, that's a really good tip. Make a simple list of the key points you want to tell the judge. When you're nervous, it's easy to forget things. A list helps you stay focused.
Smart. What if someone needs help at the hearing, like they don't speak English well or have a disability?
The courts have procedures for that. You can request a court-appointed interpreter if needed.
For free?
Yes. Court interpreters for your language should be provided. And if you have a disability requiring accommodation, maybe wheelchair access or assisted listening devices, you can request that too.
How do you do that?
There's a form, MC 410. It's best to file it with the court at least 5 days before the hearing date. That gives them time to arrange it.
Good planning advice. And for someone totally new to this, maybe feeling intimidated, any way to see what it's like beforehand.
Definitely. A great way to prepare is to go watch some eviction hearings before your court date.
You can just walk in?
Yes, these are typically public proceedings. You can sit in the back of the courtroom and just observe, see how the judge runs things, what kinds of questions get asked, how landlords and tenants present their cases. It can really demystify the whole thing.
That sounds like a fantastic idea, actually. Takes away some of the fear of the unknown.
Exactly.
Okay, so you've prepared, you're at the courthouse, your case is called. What's the usual flow inside the courtroom?
Generally, the landlord goes first, or their attorney if they have one.
They present their side.
Right. They tell the judge why they think they have the legal right to evict. They show their evidence, maybe call witnesses.
Then it's the tenant's turn.
Correct. After the landlord finishes, the tenant gets to present their defense. Explain why they shouldn't be evicted, show their evidence, call their witnesses.
And the judge.
The judge listens, looks at the evidence, might ask questions of both sides. Sometimes the judge might also suggest, why don't you two step outside and see if you can work something out?
Encourage a settlement.
Yeah, maybe with a court mediator if one's available.
Yeah.
Sometimes cases get resolved that way without the judge having to make a final ruling.
Okay. Let's dig into those tenant defenses you mentioned. What are some common specific arguments a tenant might use?
Sure. One big category is problems with the notice itself.
Like we talked about earlier.
Exactly. Maybe the landlord used the wrong type of notice, like a 3-day notice for unpaid rent when, based on the situation or lease, maybe a 30-day or 60-day notice was legally required.
Right.
Or maybe they didn't serve the notice correctly, like they just texted it or slipped it under the door when the law requires something more formal, like handing it to the person or mailing it properly. Improper service is a valid defense.
What else? What about rent issues?
Well, here's an interesting one. Sometimes a landlord serves a 3-day notice for non-payment, but then accepts a partial rent payment from the tenant after that notice period.
So they took some money later.
Right. Depending on the circumstances, a judge might decide that by accepting that partial payment, the landlord kind of waived their right to evict based on that specific 3-day notice. They might have to start over.
Interesting nuance. What about the condition of the apartment?
Huge defense potential there. It's called the implied warranty of habitability. Basically, landlords in California have a legal duty to keep the property safe and livable. Meaning free from serious problems like, major mold, pest infestations, no heat or hot water, unsafe wiring, structural issues, things that affect health and safety.
So if the place has serious problems the landlord hasn't fixed.
And the tenant notified the landlord, yeah. That can be a defense against eviction, especially for non-payment of rent. The argument is, I shouldn't have to pay full rent for a place that's not livable.
Makes sense.
Yeah.
Any other major defenses?
Yes. Retaliation is another one.
Retaliation for what?
Like if the tenant recently complained to a housing inspector about code violations or maybe joined a tenants union and then suddenly gets an eviction notice.
Smells fishy.
It can look like the landlord is trying to punish the tenant for asserting their rights. That's illegal retaliation. And finally, discrimination is always illegal. Evicting someone based on race, religion, family status, disability, etc., that's a violation of fair housing laws and a strong defense.
Those are all really important points for tenants to be aware of. Okay, so the hearing happens, both sides present. The judge makes a decision. What are the potential outcomes?
The judge issues a formal ruling called a judgment of possession. It's Form UD 110.
Then it says?
It says who wins. If the landlord wins, the judgment usually orders the tenant to move out. It's often accompanied by something called a writ of execution form, EJ 130.
Writ of execution. Sounds serious.
It is. That writ is what gives the sheriff the legal authority to actually remove the tenant if they don't leave voluntarily.
How long does the tenant...
Once the sheriff serves the writ, or a notice to vacate based on it, the tenant typically has 5 days to move out.
Just 5 days. Wow. And if the tenant wins?
If the judge rules for the tenant, the judgment says the landlord doesn't get possession, the tenant generally gets to stay, keeps paying rent under the lease terms.
Okay. Let's take the tough scenario first. The tenant loses the case. What happens in those 5 days after the sheriff posts that notice?
It's obviously a very stressful time. The tenant must move out by the date on the sheriff's notice to vacate.
Or else?
Or else the sheriff can physically remove them and their belongings. It's called a forcible eviction.
Is there any way to get more time?
A tenant can ask the court for a stay of execution. This is a request to delay the lockout.
On what grounds?
Usually they need to show significant hardship, like they have kids or a disability or nowhere else to go immediately and need more time, maybe up to 40 days to find housing. But getting a stay isn't automatic. You have to file a formal motion, explain the hardship, maybe offer to pay rent for the extra time. It's complex and honestly usually requires help from an attorney or legal aid.
Okay. And what about appealing the judge's decision? Does that stop the eviction?
No, not automatically. Filing an appeal doesn't pause the lockout unless the tenant also successfully requests and gets a stay of execution from the court, which, again, can be difficult.
Got it. And if the judgment included money owed back rent, court costs.
Yeah, that doesn't just disappear. The landlord can pursue collection efforts, like garnishing the tenant's wages, putting a levy on their bank account, and an unpaid judgment really damages your credit score, making it harder to rent in the future.
It sounds like losing has really serious, long-lasting consequences.
It absolutely does.
Okay, what about the flip side? If the landlord loses the case?
Then the tenant stays. Simple as that, usually. Depending on why the landlord lost, the judge might also order the landlord to make repairs if habitability was the issue.
Could the landlord owe the tenant money?
Sometimes, yes. If the lease or the law allows it, the judge might order the landlord to pay the tenant's attorney fees or court costs, especially if the tenant had a strong winning defense.
What if the case doesn't actually end with a judge's decision? Like if they settle or the tenant moves out?
Right, that happens too. If the tenant moves out before the trial or if they reach a settlement agreement with the landlord.
Like the one the judge might encourage.
Exactly. In those situations, the landlord is legally required to file a dismissal of the case with the court. Form CIV 110. That officially closes the lawsuit.
Okay, this has been incredibly detailed. Thank you. Before we wrap up, what are the absolute top must-knows or must-dos for a tenant facing eviction in California?
Okay, number one, I'll say it again. Do not ignore the summons and complaint.
The court papers.
Yes, you must file your written response, usually the answer form UD 105, within that 10 business day deadline. Failure to do that is likely the fastest way to lose by default.
Critical first step. What else?
Second, get legal help if you possibly can, especially if you think you have defenses. Low-income tenants should immediately look up legal aid societies.
Like the ones you mentioned?
Yes, lawhelpubaa.org and California Rural Legal Assistance at KirillAA.org are great starting points to find local help. And remember, Martinez Law Center focuses only on tenants in Orange County, Riverside, San Diego, and LA for these cases. MartinezLawCenter.com.
Good reminder. Any other key points?
Yes. Court filing fees can be expensive. If you can't afford them, ask the court clerk for a fee waiver application. That's Form FW001. Don't let fees stop you from responding.
Fee waivers. Got it.
And finally, know your rights about self-help evictions. It is illegal for a landlord to try and force you out by changing locks, shutting off utilities, removing your stuff. Only the sheriff, with a court order after a judgment, can legally remove you.
So tenants have recourse if a landlord tries that?
Absolutely. They can sue the landlord for significant penalties if that happens.
Okay, and just to quickly recap those resources for everyone
listening.
The California Court Self-Help Guide at selfhelp.courts.ca.gov is a goldmine of info and forms. For legal aid, again, KearlAA.org and lawhelpeca.org. Info also available from the State Department of Justice and the Department of Fair Employment and Housing, DFEH.
GUI resources.
And for local help like housing assistance or other services, dialing 211 anywhere in California can connect you. And all those rooms we mentioned, UD 105, SUM 130, FW 001, UD 110, EJ 130, CIV 110, MC 410. You can find them on the court's website, courts.ca.gov.
Exactly. Those resources exist to help people navigate this. It's complex, it's stressful, but information helps.
So wrapping up our deep dives today, the California Eviction Court hearing is, well, it's a serious and often fast-moving process.
It really is.
Preparation, understanding your rights, knowing the procedures is all crucial. That new 10 business day response time is a key thing for tenants to know.
Yep.
And seeking legal help is almost always advisable if you're facing eviction. And one more time, for tenants in Orange County, Riverside, San Diego, or Los Angeles facing an unlawful detainer, Martinez Law Center specializes in representing tenants. That's martinezlawcenter.com.
Being informed and acting quickly, that's the best defense strategy for tenants.
Which brings us to our final thought for you, our listeners. Thinking about everything we've discussed, the complexity, the speed, the high stakes, what do you think are the biggest hurdles or barriers tenants face in actually accessing and understanding their rights in the California eviction system?
That's a big question.
And beyond identifying those barriers, what further steps could potentially be taken to make the whole process feel, well, more equitable for everyone involved? Definitely something to think about. Thank you for joining us for this deep dive.
Call now 714-442-9741. Thank you.